On the slopes of Diamond Head. This is Kapiolani Community College. Kulia ika nu'u. Strive for the highest.
Aloha, this is Ben Carroll. Welcome back to BLAW200, the legal environment of business. Well, last time we met, we were discussing various business entities. In other words, if you're going to start a business, what type of entity, what type of format or form would be advisable for you. And so we looked kind of an overall view to start with of the various possibilities. We talked about the big three: sole proprietorship, partnership, corporations. And we also indicated there's some newer kind of hybrid forms that are much more popular now. And so we'll continue merrily on our way with partnerships and some of those limited forms today. But first, let's make sure that we've got last session's information under our belt. So, what are some factors to consider in determining what business format or entity to use? Well, we talked about there's a couple of big ones here. First one, it may be liability. So there are certain formats that limit your liability and others that leave you personally liable for your business debts. So that may be of interest, particularly depending on what kind of occupation or what kind of business you're in. Another one is taxation. So there's different taxation that attaches, particularly when we look at the corporate format. So we may want to avoid double taxation in certain kinds of businesses, so we would maybe not use a corporate form in that instance. There are a whole lot of other more down-to-earth practical things that we need to look at. In other words, do I have enough expertise? Do I have enough money? How am I going to handle control and management? Do I need to feel like that I need to be creatively in charge of everything and not share that responsibility? So again, once you decide what it is you want to do, you look at yourself and you look at your situation, and that will give you some hints which way to go in forming your business organization. Okay, what's one of the major reasons to form a corporation as opposed to sole proprietorship and partnership? So again, when we talked about the three major forms, the corporation is substantially different because the corporation allows us to protect our personal assets. Whereas if we're in a general partnership, a regular partnership, or a sole proprietorship, us and the business are identical. So there's no protection for our personal assets, and we might lose those if we have a business debt or a business liability, because us and the business are in fact one. So that's certainly a major consideration. As we talked about, the corporation is a separate entity, so it can sue and be sued, and the owners are separate from that. What are some of the benefits and drawbacks of the sole proprietorship as a business entity? Well, sole proprietorship obviously works for a lot of people in a lot of situations because it's right around 73/4 of the businesses are in fact sole proprietorships. This is certainly good for small business. It's very simple to organize, very little reporting, informal. You're completely in charge. But remember, not only are you get all the profits and all the control, but you also have all of the losses and all of the liabilities. So certainly the liability is a major concern in a sole proprietorship. Of course, there may be some other things that not so good with sole proprietorship. Since you are the business, you are the expertise, you are the resources, unless you can get additional expertise into your proprietorship and or additional capital. And it's much harder generally for a single person sole proprietor to get loans and or capital infusion. So that's some of the drawbacks. Okay, what do you get when you purchase franchise? What are you paying for? And what are your responsibilities as a franchisee? Well, as we talked about, a franchise is where you are essentially buying into an interest to be a local outlet for a larger national, usually, concern. So you have decided that you want to do this particular business, and there's already a brand name out there. There's a following for a certain type of automobile, certain type of fast food, certain type of anything else. And so you want to kind of purchase into this established customer base. So what you're buying really is you're buying oftentimes the name, the intellectual property, the way of doing business. It's set up. They've already established how we do our French fries or how we do our automobiles. And so it's already ongoing concern, and you're simply getting into something that's already put together. So that's certainly what you're getting. Your responsibilities are going to be set out pretty firmly in a franchise agreement because, again, what's being sold is the good name, the reputation, the brand, and so the franchisor is going to want to be sure that nothing you do damages that very valuable intellectual property, that franchise. So they're going to make sure that you follow the rules, keep the quality control up, even have enough sales so that you don't embarrass them by having a low-performing outlet of this kind. So they're going to be pretty strict about what you follow, what you do. You may have to buy your supplies from them. You may have to do things a certain way, have to wear a certain uniform, et cetera, so that participate in the promotions. So there are a lot of obligations here if you want to be part of something that's already designed and ongoing. You have to become part of that. So again, if you feeling more creative, you want to do it your own way, franchise won't really be your choice. Okay. What type of professional help or consultation might be useful or necessary in opening a business, and how would you locate such assistance? Well, depending on your business, obviously there may be a variety of types of expertise you need, but almost all businesses starting out are going to have some legal and some taxation or accounting questions and issues that generally you're going to need help with unless you happen to have your own expertise. And so you would need to probably get some legal assistance for various things, even deciding the type of business, perhaps, making sure that your forms, your systems are in place there, and that you cover all of the responsibilities you have in reporting, disclosure, etc. On the financial side, again, you may need an accountant or a bookkeeper or someone with financial expertise to assist you in setting up that side so that you do your proper filings, got your tax system set up, your financial recording, and you meet those responsibilities. So both of these major areas are probably going to apply to most businesses, in addition to perhaps some other kinds of expertise with technology or things related to the subject matter of your business. Now, how do you find these people? Well, the easy way is to talk to other folks in your situation and get some referrals that lead you to people that have been effective and helped others in your situation. So you'll want to do some homework here. You don't want to walk your fingers through the yellow pages. You really want to get some good information. And then you want to do your due diligence, so to speak, and meet with the professionals and actually establish a rapport and make sure that you are able to work with them, because they're involved in the real critical putting together of your business. You want to make sure that the communication, the respect, etc., is all there. What are some of the risks in operating a business, and how can we manage those risks? Well, we looked at a whole range, and again, there are a lot more materials on the website about potential risks and liabilities and downfalls in your business. And again, we've discussed over the several sessions the tort and contract liabilities, that sort of thing. We've looked at your responsibilities to your employees. So any place you have a duty or responsibility, there's always the possibility that for whatever reason is not met, and you could incur liability. In addition, not only the things you do yourself, but there may be natural disasters, there may be changes in technology or changes in the public, what the public wants. So there are these external factors that may occur as well. And you want to be prepared to deal with these as best you can, which requires planning. Now, certain types of risks you can reduce or eliminate yourself by how you do things. Others are going to be more inherent, or you're not going to really be able to avoid them. And so there are ways of getting outside assistance, for example, contracting out certain things. But particularly for small businesses with the personal liability, you're probably going to end up with insurance. So that's a major piece, and you're going to want to make sure that you are properly insured, what you can afford and what you absolutely have to have. Okay, well, we are going to move into partnerships. So we looked at sole proprietors, which is doing it yourself. And today we're going to look at doing it with other folks. So we're going to look at partnerships, various types of partnerships. Again, major area, a lot of partnerships out there as well. And there's some new forms of partnerships. So we're going to start talking about those hybrids which combine elements of other entities. And generally what we're looking at is we're combining some of the benefits of partnerships and some of the benefits of corporations, which we'll talk about next time. But we're kind of melding those together. And this is certainly a growth area. So there's a number of these that are coming out, and we'll take a look at those. And we'll talk a little bit about professional liability as well. Okay, so a partnership, this is a little bit of review. Hope you recall from last time when we kind of did the overview of these forms. Partnership is an association of two persons who conduct business as co-owners with an intent to share profits. Also, they'll share losses, but the intent's to share profits. Partners can be individuals, corporations, etc. Okay. So the court's going to look and see if, in fact, this arrangement is a partnership, because you can have a partnership without having a formal agreement. Perhaps not a good idea, but it is possible. So there may be at times questions coming up whether or not this is, in fact, a partnership. And just like the court will look, despite what you say is the case, the court's going to oftentimes need to look and satisfy itself that this is, in fact, a partnership. And the three main things they're going to look at are, is there a sharing of profits and losses? Is there kind of a joint ownership of the business? It's intended that both people are, or however many people are participating, and that there's equal right to management, or set out the rights to management. So these tend to indicate that we do, in fact, have a partnership. But you recall, even when we were talking about independent contractor, the fact you say that you are something doesn't make it so. The court will do its own review and see if you fall into that category. Okay, so what are the advantages? Again, we talked briefly about this, but the advantages to being in a partnership, some of them are the same advantages that we still have from a proprietorship. So it's reasonably easy to form and operate, a little more complicated than a sole proprietorship, because again, we're dealing with another person. There's a lot of flexibility here about how we can arrange the rights and responsibilities of partners. We can be getting an additional help in, so we can be getting diverse expertise, diverse resources. We can be adding to what we need to operate the business. So many times we may have a partnership where one person brings in expertise and the other brings in some other type of resources or assets, or maybe just the financing. But we can mix and match and put this together and increase our what we have to work with. Again, we have the same sort of taxation. It is pass-through taxation, although it is more complicated with a partnership. Some believe that partnership taxation is at least as complicated as the taxation for corporations, but it is not double taxation at least. But you probably will need some assistance with your taxation here, where even if you could have handled your proprietorship taxes. not a whole lot of regulation. There is reporting required, particularly with the limited liability partnerships, but general partnerships don't have much interference by state or federal. Okay, and the drawbacks. Well, the main drawback here is exactly the same drawback we had with a proprietorship. So a general partnership is going to have that unlimited personal liability on behalf of the partners. And we'll talk a little bit more about this, but actually your liability increases with a partnership over sole proprietorship. Now that's kind of scary, but who are we responsible for in the sole proprietorship? Well, ourselves and perhaps our employees. In a partnership, we are also going to be liable in many instances for what our partner does. So if we got 2 partners, we've doubled it. If we got 3 partners, we've tripled it. So liability remains a serious concern here. And again, we'll talk about some of the ways of limiting that towards the end of our discussion, because that is a concern with the partnership. Okay, now you're getting in new resources, you're getting in an extra body, extra mind, etc., but you're also now having to share things. So you're going to have to share control, you're going to have to share profits. So there's some issues about that. If you want to be in charge and don't want to have to bounce it off anybody else, then partnership is going to be a little hard for you. Okay, there's some issues in transferring partnership interest and termination. So just like sole proprietorship, where the business can die with you, there are certainly some termination and transfer issues in partnerships. And one that for me is probably one of the major areas is the potential for conflict, because you can argue with yourself, but it's real different from arguing with someone else. So there need to be some mechanisms here in case there is a conflict between the partners, because this can be a real problem. You're operating a business, many kinds of decisions you're going to have to make quickly. And if you have a dispute, that can be a problem. It can slow things down. It can stop things dead. So you need to have this in mind. And worst case scenario, what do we do if we have a major disagreement about something that's a major critical thing happening in our partnership? What do we do? How do we resolve that quickly, amicably, effectively, etc.? Okay. Now you remember, just to harken back a little bit, we said that the courts always have uneven numbers so you don't get a tie. But many partnerships are a couple people or an even number of people. And then what do? How does majority work if we have one on one side, one on the other, 2 on one side, 2 on the other? So again, this is a serious consideration when you get into a partnership. And we often get into a partnership and we don't think about, this is our bud, this is somebody we respect and want to be working with, but you have to look for the worst case scenario there. I think a major piece of this. Okay, so you don't have to have a partnership agreement, but very advisable for the reasons we've just looked at. So you want to make sure that these provisions are there. And so, you can, many instances, you can have a handshake partnership, but or do it over the phone. But what you really want to do is probably set all of this down, because even if you never have a dispute with your partner, it's always possible that one of you will die or become incompetent, and then people not part of the partnership will be involved in how to resolve it, how to dissolve it, etc. So much better to get it in writing so that everything's clear. Okay, so what would you want in your partnership agreement? Well, you are going to have a chance to actually draft one and see what the pieces are, but let's take a look at what would be advisable to have in your partnership agreement. Okay, obviously, name of the business, if you have a DBA or you have a logo, trade name, etc., so you need that. You would also need the names of the partners. You'd want to have something about the duration. You don't need to say something about the duration, but if there's an intent that if it's a partnership for a kind of a specific purpose, then you might put that, or you might put in another duration. You want to indicate what is being contributed, in other words, the capital or the investment that's being put in, and that can be money or it can be other things. So it can be equipment, etc., and the value. And we want to have this value in there because when it terminates, our capital contributions would come back to us. So we want to be clear what it is we put in. Now, many instances there's going to be quite a differential in what people put in. So we want it to be clear that we put something particular in if we want that back. Managerial responsibilities for each partner. Again, there's certain assumptions that might be made, but if we have particular management responsibilities, we're going to want to write that down. Okay, the accounting methods to be used. So maybe something as simple as first in, first out, or inventory, or anything like that. But certainly what kind of record keeping and accounting that we're expecting, because we both have rights, all of us have rights as partners to get copies of and look at the accounting. So we want to be sure that we're keeping the kinds of records we want. We want to talk about how the profits are going to be divided or the losses divided. Again, we may assume it's going to be equal. The law may assume it's going to be equal, but we may want a different division, and so it's important that we specify that. We're going to want to put down if partners can have draws. Generally, there's not salaries in partnerships, but there may be a draw where you can take out a portion of the profits for just as you'd use a salary in other situations for living expenses and et cetera. So you'll want to set that out as well. Okay. Want to talk about any changes that might be made in our partnership. So if we decide to add partners, that's kind of a major thing. So we want to talk about how that happens. What if there are some changes in the kind of business we do? We might have a very broad description of what our partnership does, but we may actually go outside that. We want to talk about what happens when the partnership terminates. In other words, the dissolution. We want to see what happens there, whether it's due to death or other kinds of termination. And again, very important, I think we want to talk about how we resolve disputes. If we have a major dispute about things, we want to know how to do that. Okay, now, again, just a quick example of why we might need a partnership agreement. It may be that one of the partnership forms, one of the people puts in virtually all of the money, 80% of the money, maybe 100% of the money. Other person is bringing something else, either the expertise or something else. So in the absence of agreement, there might be an assumption that things are all 50-50 with two people. But if the person that contributed all of the capital, or the majority of the capital, wants that to come back out upon termination, and certainly if it's their heirs or assigns or somebody that's trying to get that, it's important that we put that so that it's clear there that no, it isn't 50-50. We have something specific here. So this may sound a little bit like when we were talking about, for example, sales contracts where the court will fill in the blanks. And we do have some law that will fill in the blanks for you if you don't put it down specifically. And again, also happens if you write a last will and testament. You want to tell people where things go. However, if you don't, the law has made some what they hope are common sense determinations that in the absence of written provisions, this is where things will go. So again, you want to specify that in your written agreement so that it's not falling back on the default provisions, the 50-50 or whatever, that the law will say applies. Okay, now partnership duration, we talked briefly about that, but it can be for a certain term or to the occurrence, a certain kind of occurrence, or it can be at will, which means that you can terminate it according to its provisions whenever one likes. And again, just a quick note that we can have partnership by estoppel just as we have agency by estoppel. And you remember, whenever we talk about estoppel, we're talking about we have made someone else believe something. We have made representations and caused them to rely on something. And then the court will probably hold us, if we try and deny agency exists, partnership exists, the court will say, you cannot do that. You are stopped from denying that because you caused them to believe that this person was part of your partnership, even if they weren't, and if they relied on that, then they're protected. Okay, now I mentioned that the law is going to make certain assumptions if you don't have it written down in your agreement. And many states, Hawaii included, have adopted the Uniform Partnership Act. So we've become familiar with what uniform laws are. And again, these are laws that are put out by NACUSL, National Conference of Commissioners on Uniform State Laws, sometimes in association with ALI, American Law Institute, or other organizations. But these are put out as models so that we have uniformity across all the states that have adopted it. And the Uniform Partnership Act has been adopted in many, many states. Now, this provides uniformity, as you would expect from uniform, and so it also makes a lot of provisions that will apply in the absence of agreements to the contrary. So if you have an informal partnership, it's a handshake, you just say, let's go into business, let's do this, let's divide our profits, let's be in a joint enterprise, etc. If you meet those requirements that looks like you're intending to be in a partnership, even if there are no other provisions, the Uniform Partnership Act will fill in those blanks for you. It will make certain assumptions that are going to apply and are going to govern your partnership if you have not provided otherwise. Okay, so a lot of these will have to do with management. So the assumptions are everything is equal unless otherwise indicated. So you will have equal management rights, you'll have equal votes, and again, as we mentioned in our hypothetical, even if you contributed much more or all of the capital, you're still going to have an equal vote unless there's some distinction there, unless you put it down. Okay. Now, most partnership decisions can be majority vote. Again, problem if you got two people, who's the majority, but decisions in general can be majority vote, but there are certain exceptions, and we make these exceptions when it's something very critical to the whole purpose of the partnership or greatly affects the rights of the partners. Then we're going to need more than majority vote. So we're going to need unanimity in certain instances. So what are those kinds of things that are so important that everybody's got to agree on? Well, if we're going to alter the essential nature of the partnership or enter into a brand new business, okay? If we're going to amend the partnership agreement, if we're going to change our basic governing document, everybody's got to agree. If we're going to bring in new partners, because obviously bringing in new partners is going to dilute the profits that are involved. It's going to dilute control. So this is critical. This is essential, and so this is going to require unanimity too. Again, altering the capital structure. If we have different kinds of capital contributions and now we're going to change that, everybody has to agree. Okay, a couple. Now, what's the partnership interest? What is your interest in the partnership? Well, as I mentioned earlier, you don't get a salary generally, but you do have your interest, and so that's the profits. You have a share of the profits, and you can have what we call a draw, partnership draw, which means that you pull out profits when you need them, and you need arrangements. You'll need something in your agreement to indicate how that happens and whether there are limits, etc. And then at the end of the termination of the partnership, your interest would include your capital contribution. Okay, so those are your partnership interests. Okay, we've talked about assignment, and you can, in fact, assign your partnership interest to another. So you can pay a debt, perhaps, with your partnership interest. You can assign that, and that person will now be entitled to your share of the profits and to whatever capital you put in when the partnership terminates. So they are now in your place, at least with respect to your partnership interest, receiving the amounts due you. However, being an assignee, being the person who has received a partnership interest by assignment, does not make them a partner. So they have no interest in managing, no right to inspect books. They simply have a right to receive the monies due to the assigner, due to the original partner. And your partnership interest can also be subject to a lien. So it is a property interest, and it can be treated as the other property interests that we previously discussed. Okay. Again, there are some other areas where the partnership property, where the agreement needs to be unanimous, and that's if you are doing this assignment of a partnership property, if you're disposing of goodwill, if you're doing some kind of act that would make continuation of the business impossible, or confessing judgment, in other words, admitting liability. So these are issues that would require unanimous decision making. Okay, so what's a partner's authority? Well, we mentioned earlier that this, in fact, is an agency relationship. So you are an agent of the partnership and also an agent for the other partner. And this has a number of implications. So again, we talked about partnership by estoppel, goes right back to agency by estoppel. So if you make other people think things, that's just like agency. Ratification would apply. So if your partner does something, even if it's outside the authority, you can ratify that. Another critical thing is the knowledge of one partner about the partnership business is imputed to the other partner. So whether you know it or not, that knowledge is imputed to you. And you recall when we talked about agency, it was important to disclose and to keep the principal advised. Same thing in a partnership. It's important that you keep your partner advised what's going on, because what you know about the partnership business, they know, whether they know it or not. It's imputed. Okay, there's duties of a partner, or again, we can look back and see the duties that we looked at agent to principal, and vice versa, principal to agent, because we're both of those in this partnership. So again, we're all in that boat together. Now, the two critical ones probably are duty of loyalty. So any profit, benefit, property that you receive through the partnership business or from the status of being a partner, you're accountable to that, to your other partners, so that you're only entitled to your share of that, whatever it may be. Even if you're the one that actually receives it, you're receiving it on their behalf. Okay, so again, this is like the fiduciary responsibilities we talked about with agency. You also have a duty, under this duty of loyalty, not to be involved in a conflict of interest. So you need to keep your partner's interests in the forefront as well. Okay, there's the duty of care, and I think we call that the duty of performance as well. There are a number of titles here, due diligence, etc. But this is your duty to avoid doing negligent things, intentional things, or reckless things, or violating the law to the detriment of the partnership and your partners. So again, these are the same essentially. We've just highlighted a couple, but these are the same duties that arise out of the agency relationship, because that's right what you are. Okay, now what's the liability? As I said, the liability is even more than a sole proprietor, because not only are you responsible for your actions, but you may incur liability from what your partners do. So that can certainly be tort liability. It can be contractual liability, because if the partner, like an agent, operates within the course and scope of their authority, that binds the partnership. So that's covering your interest as well. Okay, now if somebody is clearly outside their authority, then that's only going to bind the partnership if the other folks ratify it, if the other partners ratify it. But again, there may be a estoppel here if, in fact, you have third parties involved. Okay, so your liability on partnership obligations. Many states, including Hawaii, have what we call joint and several liability. So the joint probably makes sense. It means we're liable collectively, jointly with our other partners. And that's the case in virtually all states, but in states like Hawaii that have joint and several, that also means that a third party doesn't have to sue all of the partners. They can only sue one of the partners for something that went on, and that partner would be fully liable for the judgment. Now, can that partner go against the other partners that perhaps did the dastardly deed? Sure, we would have that right because of the partnership agreement, but the third party doesn't have to bring them all in. If it's joint and several, they can bring it against just one. They don't care where they collect it from. Then you're on your own to get your other partners that may be responsible in. So, okay. Now, as a general rule, you're not going to be responsible for the personal liability of your partners. So that's the good news. Now, if you have incoming partners, then they're only going to be responsible for prior debts and obligations up to the extent of their capital contribution. So they're not buying into the debts and liabilities from earlier, only from the time they enter the partnership. Okay, under the Uniform Partnership Act, and of course you'd want to include this in your agreement as well, you have a right to accounting, so you have a right to look at all of the books and records. You have both a right to receive and a duty to disclose any information about the partnership business. You can copy any records and inspect, and you can demand a formal accounting from the partnership as well and from the other partners. So again, these all should hopefully sound very familiar from agency responsibilities as well. Okay, how's a partnership terminated? Well, this, I believe, looks like old hat by now. So the same way we terminate contracts, the same way we terminate a lot of different relationships. So we can certainly have something right in the agreement that covers that. There's voluntary or involuntary withdrawal, death of a partner. If new partners are included in and there's been no agreement to that, that would destroy the partnership. Bankruptcy, judicial decree. Now, when the partnership terminates or dissolves, then notice needs to be given to all the affected people, which obviously are the partners, any creditors, suppliers, etc., and again to anyone else, third parties that have an interest or are affected. Okay, so what we've been talking about is a general partnership. So when we say partnership, if we don't say anything else, we're generally talking about a general partnership. And so the rights and responsibilities, advantages, disadvantages that we've talked about are for a general partnership. But we've talked about limiting liability, and the way we do that is separating ownership and control. Okay, and we haven't separated ownership and control in a regular partnership, so everybody's liable. So with these new organizations where we're allowing the limitation of liability, the state's going to be more concerned with making sure that the public knows that, so making sure that people know that you have a limited liability situation. So these are going to require formal agreement. So we're not going to allow people to simply have an informal partnership, because if we're limiting liability, we want people to know that that's the case. And so you're going to need to comply with the statutory provisions in each state that set up these limited liability entities. So again, most states are going to require that you have something indicating limited liability, so perhaps the initials after LLP, LLC, these various designations, so that somebody seeing the name understands that you have a limited organization. Okay, now these are all hybrid organizations. So we used that term earlier, and what are we really talking about when we say hybrid? Well, we're talking about moving from the personal liability that we have with proprietorships and regular general partnerships over to the limitation, the absence of personal liability over at corporations. So again, as we earlier indicated, we had proprietorship, partnerships, corporations, and now we're kind of filling in this continuum with a variety of different types of organizations where the liability is limited. And the reason we use the term hybrid is because we are combining some of the aspects that we like about the proprietorship and the partnership with other benefits that we have with the corporation. So what are those? Well, it's the two major things we already talked about. So we like the limited personal liability or the absence of personal liability of the corporation, but we like the way that the taxation happens where it's passed through taxation and we're not doubly taxed on our profits here. So these various organizations, there's a slew of them that have come up, are now filling in those blanks and trying to combine the best of those types of entities. Okay, now, each state passes its own laws that tell us about limited partnerships, limited liability partnerships, limited liability companies, and so these may all differ. Now, there's some uniform acts in this area, as we've talked about previously, such as the Uniform Partnership Act, but this tends to be a very fluid area, and these are different versions coming out, and so various states may be at different places. They may have adopted different versions, or they may have come up with their own. So this is very much a developing area, and you need to look at the statutes in your state. Another issue we'll talk about in a minute is if you're operating in several states, you may be operating in places that have different limited liability provisions. Okay. So the first limited type of entity is a limited partnership. So the partnership we've been talking about, again, is a general partnership where all the partners are essentially equal. They're all liable in the same sort of way. There may be differences in their profit percentage or something, but essentially all the partners in a general partnership are general. They're partners. Now, in a limited partnership, we are going to make a distinction between two different kinds of partners now. So on one hand, we're going to have general partners, and those are partners that act just like partners we've talked about. But we're going to have a new sort of partner, and we're going to call these limited partners. And the limited partners, we are limiting their liability. So how do we do that? Well, this is a principle we've mentioned several times. We're going to limit their liability by limiting their control. So we're going to separate control and liability. What does that mean? It means the limited partners are not going to really participate in management. They're going to be divorced from control, and that's also going to divorce them from that personal liability. Okay. In general, the limited partner is going to have a lot of the same rights, most of the same rights as a general partner. So the limited partner will be entitled to information about how the partnership's doing, profits, etc., return of capital at dissolution, that sort of thing. What they're going to give up and what they're not going to have is they're not going to have management rights. Okay? As long as they keep out of management, then their only liability is going to be for the amount they put in other words, their contribution. If, however, a limited partner starts getting their hand in management and starting to act like a general partner, then they're going to be treated like a general partner, and they may incur liability that they sought to protect by being limited. So they need to kind of stay out of the kitchen, stay out of the management and control to maintain that personal liability limitation. Okay, now there's an additional kind of partnership, and this one is designed really for professionals in the field, different fields. So one of the problems when you're in a profession, and partnership was kind of the usual way that doctors, lawyers, accountants, etc. used to practice. One of the problems here is, although you may talk about a client of a particular law firm or accounting firm, but as a practical matter, they're just dealing with usually one partner. So maybe other folks involved, but a lot of times it's going to be kind of a one-on-one with the professional. So the other partners may not have any idea exactly what's going on in that relationship, and yet they're going to be responsible for that partner's actions. So that partner can incur liability, malpractice liability for them, even if they're not part of what's going on there. So limited liability partnerships developed for this very situation. So it would protect the partners from the malpractice of their partners, but they'd still be liable for some of the similar debts, like the amount of their contribution would have to pay if the Xerox bill or the rent bill or whatever wasn't paid. So it would protect them from the negligence or malpractice of their partner, but they'd still be on the hook for what they did themselves, obviously, and for the partnership acts, such as contracting with landlord and that sort of thing. Okay, and then another area, and this is one of the newest, are limited liability companies. So this is kind of the growing area. First started out actually quite a few years ago in Wyoming and kind of spread like wildfire. So there's a little bit of that history on the website that will tell you how this happened. But very, very popular now, because this is kind of, many people think, the culmination of combining the tax benefits of the partnership and the flexibility and limited liability of the corporation. Okay, so it does have those pass-through tax advantage of the partnership, and it does have the limited liability, personal liability of the owners. So again, that means that the owners would be liable only for their investment, not for personally liable. Okay, so they receive this again because they're kind of combining the both aspects of both, and so they're allowed to have benefits of both. And initially it wasn't clear that the tax authorities would accept this, but they have, and so as I said, this is many states have LLCs now, very kind of the growth area. Okay, so we call the owners, we call them members, and they file articles of organization. So again, we'll have different titles for our governing documents. And some states will require that an LLC have more than one member. Hawaii and a number of other states, one member is fine. Okay, so again, area where the state statutes will differ. Okay, LLC can be owned by corporations, partnerships, etc. And we'll use the term closely held when we talk about corporations, but it does not need to be closely held, which means that there can be investments here. So this, you'll see, is different from your proprietorships and your partnerships. It's getting more like your limited partner, but it has that ability to attract the investment. So again, you can see we're combining the best of what we have in the corporate arena with the tax advantages that we have in the partnership area. So kind of the best of both worlds. Again, the statutes, all of the state statutes, are going to require that you be very clear that you are, in fact, a limited liability organization. So it's indicated in the naming that you have to indicate with either limited liability company or LLC that you are, in fact, limited. Again, put the public on notice. Okay, so what are the advantages? Well, you have flexibility, so there are still fewer restrictions than there would be with the corporation. It's easier to set up a little bit. You do have the profits passing through. You have the tax advantages of the partnership, and you have the limited liability of the corporation. Okay, what are some of the disadvantages? Well, it does have a little more formality. Again, any of these instances where you are able to limit your liability to the public, the states are going to be either having a uniform law or their own laws to set that up, and there's going to be a certain amount of compliance. But perhaps the main problem with these newer forms of enterprise is that we don't have a history of how they're going to be interpreted. So we don't know exactly how courts are going to treat them because there isn't that much precedent. So we have a lot of different laws applying, and we have different versions of uniform laws that are out there. And so the courts haven't really had an opportunity to build up a body of law that would help us interpret how exactly this entity is going to be treated in different situations. So that's the main problem, is that we are kind of being experimental. We're kind of being the beta test for how this is going to be treated. And again, as previously noted, a lot of the states are going to have their laws aren't exactly the same, so it may be that we have this sort of protection in one state, but if we're operating in several states, we're not clear that the limitations of this particular form are limiting our liability for actions in that state. Okay, so the management is covered by the operating agreement. It covers the same sorts of things we've looked at in partnership, so you'll certainly have to cover the dissolution, the ownership transfer, that sort of thing. And it may also cover the usual sorts of things about how to vote, etc. Okay, there are two different flavors, so to speak, of LLCs. So you have member managed, and this kind of operates like a partnership where all the owners participate. And there's also the option of having what we call manager managed, which means you can have a management team, and they would not even need to be the members, so they could be outside management team. If you don't specify, then it's assumed that all of the members participate in management, just as we often do with a partnership. So this is very flexible. Again, you have a number of options here, and that's what's attractive to people, is maintaining that flexibility while collecting together the advantages of the various forms. Okay, now there's a whole lot of other entities, and so we will talk a little bit about these, but you can see that the statutes provide a variety of types of things. For example, in Hawaii, we have joint ventures and cooperatives, and these are pretty generally accepted across the country, and also nonprofit corporations. But we have a variety of other specialized organizations that are set up by statute that would apply in different situations. So some of these are more in the kind of the nonprofit area, or agricultural cooperatives, or community associations, that type of thing, as well as some specialized corporations such as professional corporations or ecclesiastical or church corporations. And again, we'll talk a little bit about the corporates side next time we get together. But the professional corporation sounds very similar to the limited liability partnership that we talked about today. In other words, it's for professionals and fills in that need where the other people in your organization are very specifically dealing with individual clients. Okay. Want to mention just a couple. So joint ventures, it sounds very similar. We've talked about a lot about joint, but what exactly is a joint venture? Well, this is just people that have gotten together to do a particular enterprise, and sometimes these can be short-lived, so these may be term limited. In other words, a joint venture on a particular construction project, that sort of thing. And since the activities are more circumscribed and perhaps duration limited, then there's less implied and apparent authority here than in a regular agency or partner kind of situation. But it does have some differences with partnership. Generally, it can continue on with death of a joint venture. And also, since these entities that get together also have other things going on, there's often the chance in a joint venture that there can be conflict of interest or that type of situation where working on this project may have an impact on something that's in our joint venture. So there needs to be kind of full disclosure in these situations. Okay, and finally, I just want to talk a little bit about professional liability. So we've looked at some of the already one of the entities, the LLP, Limited Liability Partnership, that's meant to deal with professional situations, and we'll again look at a professional corporation briefly. But a number of you probably are going into accounting and perhaps law and some other occupations that would be affected here. So I want to talk just a little bit about professional liability. So again, many times we've talked in the past about people that have special knowledge or expertise. So we're held to a higher standard, and there are other guidelines, ethical concerns that we have to follow. So not only are we looking at kind of a higher standard of care with respect to our services, but we also, of course, have to follow whatever it is we've contracted for, because people are coming to us for a particular level of service. Okay. Now, this is an area where, although we protect ourselves with respect to the entity itself, in other words, we try and limit our personal liability for the acts of the other professionals that work with us. Also, this is an area where we are probably going to get malpractice insurance. So most professions are going to have malpractice insurance for negligence in their professional work. And so we talked a little bit about liability policies, and with respect to professional liability policies, there are some differences. So, for example, many doctor policies require that the doctor can veto a settlement by their insurance company. So they have a lot more control over this. And this is because professional reputation is important, and they may not want to settle a case, they may not want to pay out on a case if it's going to impact their professional standing. Okay. Now, we will, on the website, there's a number of articles about particular types of liability for accountants, lawyers, etc. And we will be talking about some more of the responsibilities in these areas when we get into the corporate regulation. So we'll talk about the Sarbanes-Oxley Act, which in particular affected a lot of accounting and auditing standards and responsibilities as well. So again, just wanted to touch on that, but there's a lot more information for you there. Okay, do take a look at the website. There's a lot of material covering these entities. There's some charts and graphs and matrices that kind of lay out what these entities look like, because we've just kind of zipped through a range of these, and they're kind of, as I said, on a continuum, and there are various reasons you might pick one or the other. In different states, you might, with the same situation in different states, you might choose different entities depending on how that state's law work. But it's kind of a blinding array right now of, do I want an LLC or do I want an LLLP, or the acronym soup. So do take a look at that. Okay, well, next time we are going to get into kind of the granddaddy of the business organizations. We're going to look at the corporation and see how that works, because as we talked about, that's its own separate entity. There's a lot more moving pieces, so we're going to take a look at corporations and how they work. Okay, so this is Ben Carroll saying aloha till next time. See you then.